Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content. And today will be the day I earn that subscription. For today's coverage, we'll be talking about the Johnny Depp case in the view of defamation and how we got to where we are in terms of public figure. Why you have to show this elevated standard of what's called actual malice, which, as we know, doesn't mean anything about malice because it's just badly named. What it means is that you know what you're saying is false or recklessly disregarding the truth thereof. So where did this come from is where we're going to be starting today. And to join me in discussing these constitutional principles is my friend Rob from Law and Lumber. How are you doing, sir?
I'm doing quite well, Kurt. Can't wait to see you pick up where I left off and drop the ball and failed to continue discussing New York Times v. Sullivan.
Outstanding. Yeah, so we are going to discuss New York Times versus Sullivan and also a companion case that extends its logic. And it'll be very interesting to see how the case extends, because I think by going to both cases and showing you where it starts and also the extension of it, you can see how the case, starting from fairly benevolent principles and fairly clear principles, has gone extended and extended in ways that perhaps was not intended. But we'll get there in a minute. So anyways, we're here to discuss the issue of defamation. So as I'm sure many of you know, for defamation against a private person or a matter of private concern, you typically only have to show negligence. That is, that you had a duty, which is to tell the truth, basically, and failed to do your duty in terms of your due diligence. So again, just because you told a lie doesn't necessarily mean that you're guilty of defamation. You have to show something more. You have to show that you disregarded something, that you weren't sufficiently careful. So again, it depends on a whole host of factors, right? So just merely a rumor from, some random guy is probably not going to get you past the negligence threshold. But if it's a person of sufficient repute, or if you hear from a couple different people of sufficient repute, then you're probably in the clear. This, incidentally, is where the newspapers got their idea originally of having 2 or 3 sources to confirm something, both in issues of trying to make sure that they're giving good news. And of course, when they're dealing with private persons, if you have 2 or 3 independent sources, the idea at least is, even if you are wrong, that you've shown your diligence, that you've shown that you're not negligent in observing your duty. But for public people or matters of public concern, we need more. We need to show more than mere negligence. We need to show actual malice, which means one of 2 things. We actually know what we're saying is false or we recklessly disregard. Now, actually knowledge is usually pretty hard, because how would you actually know? The only way you would actually know is if you were actually there, because otherwise you would have no actual knowledge. So, for example, in Johnny Depp's case, I think with respect to Amber Heard and the defamation statements that she allegedly made, I think actual malice is a given. So although it's normally difficult, I think it's a gimme, because, well, Amber Heard, how would she actually know? Well, it's pretty easy, because the abuse either did or did not happen to her, because she would have been there. Right? There's no way to avoid this. Like, you were there at the time when the abuse either was or was not happening. So, there's that. That's how you would actually know from the being there. So that would be, your normal thing. So normally actual knowledge is really hard. But you still have this other thing of reckless disregard, which again is pretty hard. Here we're not just talking about, that you didn't do your due diligence. We're talking about, material that is so amazing or so unbelievable or so something that would require more diligence, require you to do something more. And then, even then, you can usually get by with it by showing that, where you have doubts, that you report on your doubts. So it's just, if you have some doubts, you can be like, well, sources seem to indicate this, but also there's some indication of this, right? So that's a way to get to show where our information is leading to this opinion or these facts, but there seems to be this counter. And this is also, incidentally, why newspapers very commonly ask sources for comment, because regardless of whether they comment or not, they gave them the opportunity to comment and clarify the record, so they can't therefore be recklessly disregarding, right? It's like, we gave you a chance, whether you took on it or not, that's not our problem. If you took it on, we'll print your denial or whatever, and now we're no longer recklessly disregarding. So that's where your baseline principles of why things are done the way they are. So all this making sense so far?
I'm getting it. So the more salacious the comment, so the more outlandish the comment, the more it kind of imports on the media source to double check the sources. And it's like if you're going to publish something that's that egregious, you better at least check it once. And if you don't, then that can be a reckless disregard based on what you're actually reporting.
Yeah. And also, this goes a long way to showing why, for example, it's basically borderline impossible for Johnny Depp to sue the Washington Post, for example, because the Washington Post has it from Amber Heard, who, would have been there. It's a pretty reliable source. It's like, well, I was there. How do you know? Well, it was happening to me. And so that would on, at least on superficial level, seem to be a pretty credible report. So this is why it's basically borderline impossible. Amber Heard for sure know it's false because she was there. But how is Washington Post supposed to know? They certainly weren't there. And how were they recklessly disregarding by taking into account an apparent firsthand account of this happened to me? So this is exactly the thing, right? And but as you're dealing with your general idea is right. As you're dealing with things that seem more detached from reality, things that seem more incredible in the literal sense, as things seem more problematic, it requires you to dig a little bit more. But again, it doesn't require you to dig infinitely. And we're just trying to avoid recklessness. Recklessness is basically wanton disregard. It's devil may care. It's complete, when you think about reckless driving, the whole idea is not that I'm just merely driving unsafely. Is I'm driving in such a wanton, careless manner that basically something was bound to happen eventually, and so basically I absorbed that. It wasn't just that I was paying attention. I'm driving so fast on such speeds of, the roads and whatever that, something was inevitable. What that something was, I didn't know, so I don't have knowledge. I may not have intended it, but, I exhibit such carelessness that, some sort of bad consequence of some variety was readily foreseeable. And so too from driving to the reporting, right? It's the same kind of principle. And you just do it by analogy. It's like not just that, I had some indications, not that I was just merely going over the speed limit or a little bit this or a little bit that. No. I was engaging in such blatant disregard of information. I had such, powerful information on the contrary, which incidentally, I didn't bother to tell anybody about. So that's a whole nother problem. But if I do, I'm probably okay. But such blatant disregard and carelessness and wanton, willful blindness that something bad was bound to happen. And this something bad in this case would be that I made you look to be a horrible, horrible person. Hence defamation.
The willful blindness part.
Yeah.
That's probably the best way to describe what a reckless disregard is. It's willful blindness when you kind of feel like, and in your heart that something is wrong, and you have this, I am going to willfully disregard this truth that I know is true.
Yeah, without doing any sort of verification or checking, without doing your due diligence, as one might say.
Yep.
So anyways, we have to start where it all started, which is always a good. Now, before New York Times versus Sullivan, the case law was state-based on defamation. And so basically the standard for a public and private person was exactly the same. You show your negligence and you're there. So let's start with where it started. It's always a good place to go to the beginning.
I love it. Start where it started.
So here is where it starts in the beginning. This is the original advertisement that appeared in the New York Times. This would be the New York Times part of New York Times versus Sullivan, right? Someone bought an ad. They bought a full page ad for $5,000 in 1960.
That's a lot of money back then.
Yeah, $4,800, I think, something like that. But here's like this whole thing, right? So it's a full ad bought and put in the New York Times, full page ad in the New York Times editorial in the 1960s, and talking about your help is needed urgently now. Committee to defend Martin Luther King, struggle for freedom in the South, right? So it's a public service ad by Committee to Defend Martin Luther King, a whole bunch of people, and it's making a whole bunch of statements about things that are happening in the South and blah, blah, blah. Sullivan is a sheriff, and he thinks that he is being imputed by this ad. So here's what it actually looked like, but we're going to go to the opinion and discuss what it has to say on the subjects, okay? So this is the second case we're going to discuss, by the way. So here's the one we start with, 1963. 1964
Okay.
is when it's
Can I
decided.
make like a brief interlude here? I love that you
Sure.
pull the original PDF.
Yeah. I personally like reading Supreme Court cases in their original PDF. I wouldn't do this for a Court of Appeals case, but I don't know. Something about the Supreme Court, I just am used to reading them in their original outlay. So I personally like it that way. So,
Yeah.
personal stylistic choice. But, this is how it's actually printed on the physical page. So why not, right? So here it is, decided 1964. So I've highlighted some key parts for us, to show you some things. Now, I think it's important to note like where we are in this. So one of the things I want people to take note of is the kinds of statements that are being involved and the kind of person that's being involved in them, because I think it's interesting to see how the case law, I guess for lack of a better description, has drifted, right? So I think New York Times versus Sullivan unto itself is pretty easy to defend sort of on its own terms. Like you're dealing with some pretty strong statements, but it's a public person who's accepted a public job. And so they need to absorb a little bit more. But the nature of the statements and the nature of the person are very material. And so it'll be interesting, I think, in sort of comparison when we see this initial case and we sort of think about how things have drifted away from these really strong cases to much weaker things, and how the nature of who it applies against has definitely expanded from the public official to public persons, and how that concept has expanded. So just one of the things I want to bring attention to, because it's interesting to see by going back to the original how the case law has developed or drifted as you're maybe. All right. So the first thing we're into is why are we here? We're required in this case to determine for the first time the extent to which constitutional protections for speech and press limit a state's power to award damage in a libel action, which is written form, because this is an ad, so defamation, in a defamation action brought by a public official against critics of his official conduct. So this is the first place we're starting, right? Public official conduct, right? And all defamation law is state law, so that's neither here nor there. But we're starting with that concept. So I think that's notable. So here are the actual statements that are at issue in this case. So from the third paragraph of the ad that we saw earlier, quote, in Montgomery, Alabama, after students sang My Country 'Tis of Thee on the state capitol steps, their leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campuses. When the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission. It's pretty strong claims. Sixth paragraph, again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and several offenses. And now they've charged him with perjury, a felony under which they could imprison him for 10 years. So, yeah, we're making some pretty bold claims here against the authorities.
Each one of those sentences is viewed as an independent sentence standing alone, right? Like each one of those?
Yeah, pretty much. Yeah. So, I mean, there's some pretty strong claims being made here against the state police in terms of what they are or are not doing vis-a-vis the protesters relating to Dr. King in 1960. So, and this is being decided in 1964. Okay, so then, although neither of these, this will sound familiar, this part, although neither of these statements mention respondent by name, that would be Sullivan, he contend the word police in the third paragraph referred to him as the Montgomery commissioner who supervised the police department. So it's like, it didn't mention me being my name, but I am being defamed by implication because I run the police department. So therefore, he was being accused of ringing the campuses with police. So he was engaged in this action. He further claimed the paragraph would be read as imputing to the police, and hence to him personally, the padlocking of the dining hall in order to starve the students into submission. So that he was the one authorizing this, ringing the campus with the police officers, locking the doors to the dining hall so they would starve, and, that he would win that way. So that's the kind of things we're dealing with here. As the sixth paragraph, he contended that since arrests are ordinarily made by the police, the statement, they have arrested Dr. King 7 times, would be referred as referring to him. He further contended the they who did the arresting would be equated with they who committed other acts. So he's saying, okay, look, you're talking about a whole bunch of things that have been happening here. You mentioned the police explicitly, so therefore these other things could be read as being done by the police, right? That would be the relevant context. We talk about the
Yeah.
police in one thing, and then we don't name the antagonist directly, so it must be the police. Reasonable conclusion. I am the head of the police department. Therefore, you're saying I personally have done all these things, that I personally have starved them and lined the campuses and arrested Dr. King and blah, 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 all the rest of it. So, notable. Okay, so we're starting off intensely here. We're not
Just a little bit, just a little bit of fire, just a little bit of fire here. Like it's like, hey, police, I'm taking that to be me.
Yeah.
It sounds like defamation by implication.
Yes, it certainly does. Okay, so the Supreme Court is now going to lay some facts on us in terms of what the factual record is. It's uncontested that some of the statements contained in the 2 paragraphs were not accurate descriptions of what occurred in Montgomery. Then you can decide the degree to which this matters, but there were some false facts. So let's discuss the facts that are, at least according to the Supreme Court, that are uncontested. Although the students staged a demonstration on the state capitol, they sang the national anthem and not "My Country 'Tis of Thee." Again, do you care? But it's a fact, right? It's a mistake. Although 9 students were expelled by the State Board of Education, this was not for leading the demonstration at the Capitol, but for demanding services at a lunch counter in Montgomery County Courthouse on another day. So expelled for a different reason. Not the entire student body, but most of it had protested the expulsion, not by refusing to register, but by boycotting classes on a single day. Okay, that's a bit different, right? It's not everyone, some of them, and it's not registering, but simply taking the day off class. So that's a little bit different. Virtually all the students did, in fact, register for the ensuing semester. The campus dining hall was not padlocked on any occasion. And the only students who may have been barred from eating there were a few who had neither signed a pre-registration application nor requested temporary meal ticket. So basically, they were not entitled to eat there because they were just rando people as far as the college was concerned. So they refused to seat them because, not so much. So that's a little bit different. Although the police were deployed near the campus in large numbers on 3 occasions, they did not at any time ring the campus, and they were not called in connection with the demonstration on the state capitol steps, as the 3rd paragraph implied. Dr. King had not been arrested 7 times, but only 4. And although he claimed to have been arrested some years earlier in connection with his arrested for loitering outside a courtroom, one of the officers who made the arrest denied there was any such assault. So again, the degree to which you think these facts may or may not matter in terms of the analysis, fine. But there are some false statements of fact. So apparently there are some false statements of fact that are being communicated and published to third parties, and then the rest might be open to the jury. Okay, does this tend to harm their reputation versus the pleaded truth, incidentally? Because that's also a defense in defamation law. If there's no difference between the pleaded truth and what they said, then it doesn't matter, because basically the idea is there's no damages. So it'd be like me saying, I don't know, X has murdered 7 people, and be like, well, that's not true. I only murdered 5. And it's like, no one cares.
Murder's still murder.
No one cares. We think the 5. We don't think that there's really a lot of people who are going to have much stronger of a feeling against you for 7 versus 5. So, we don't really care that much. So you could view some of this as falling into that category or not. But then again, those are questions of fact for a jury. How am I doing so far, Rob?
Pretty good. I mean, honestly, like 5 murders versus 7, I'm kind of thinking it's still murder.
Yeah. And it's just an example. And then you could, obviously do the same thing here. I mean, some of these statements seem material, whether or not ringing the campus versus being on campus in heavy numbers is, to my mind, doesn't strike me as that much a material difference. But, we padlocked the dining hall versus, not so much with the padlocking. And no one was denied the right to eat except those who basically had no right to eat because they didn't pay or register. So the college was like, who are these people? And also, like, the students didn't refuse to register. They just took the day off class. I mean, those are kind of different. And we didn't arrest them 7 times, only 4. And, for some reasons that aren't this. So, there's daylight there, I think, that might cause someone to have a more negative reputation of Mr. Sullivan than might be deserved by the actual facts, or at least arguably. That's what juries are for. Okay, great. Carrying on. I just want to make sure by asking you every once in a while, make sure that I'm, explaining things okay, and that I'm not blowing past things or
No,
whatever.
you got me. I've missed half of those things. Like, and reading that out and kind of looking at every sentence in isolation and how many misstatements were in there, that's kind of intense.
All right, so let's talk about what happened at the trial court, because that will obviously help understand what the state of the law was before and how the Supreme Court's changing. It's always helpful to read these things because you understand what we're moving from and what we're moving to. So the trial judge originally submitted the case to the jury under instructions the statements in the advertisement were libelous per se, which, it goes to someone's profession. So, and that is a classic ground for libel per se.
Yep.
Talking about someone's profession. So fine. We're not privileged. They're not in any sense that we would recognize. They're still not privileged today. So petitioners might be held liable if the jury found they had published the advertisement and the statements were made of and concerning the respondent. Again, is it about him? Because it's defamation by implication. So, we still have to find it's about him to have standing. So, okay, fine. The jury was instructed that because the statements were libelous per se, the law implies legal injury from bare fact of the publication itself, which is still true today. Falsity and malice are presumed, not so much now, right? Because falsity, no, and malice, definitely not. General damages need not be alleged or proved. Still true today.
That's still true today. Yep.
And punitive damages may be awarded even though the amount of the actual damage is neither found nor shown. Correct.
Still true today. Still
true today. So some of this is still true today, but what is not so much true today is falsity and malice are presumed. Okay. An award of punitive damages, as distinguished from general damages, which are compensatory in nature, apparently requires proof of actual malice under Alabama law. All right, fine. And the judge charged that mere negligence or carelessness is not evidence of actual malice or malice in fact, and does not justify punitive damages. So at least as punitive damages, apparently, they were kind of there.
Punitive, higher standard, though. So punitive, higher standard, we recognize it needs to be higher.
Sure. He refused to charge, however, the jury must be convinced of malice in the sense of actual intent of harm or gross negligence or recklessness to make the award, and also refused to require the verdict for respondent differentiate between compensatory and punitive damages.
Ooh, big no-no.
Yeah, that's, not so much today on that either, on that aspect. All right, so that was where they are on that. All right, so skipping ahead because there's a lot. Obviously, I didn't highlight everything because that would be dumb.
These opinions are like 90 pages, guys. Like, you cannot highlight all of it.
No, and I'm trying to highlight. I'm trying to, like a teacher, right? Trying to highlight particular issues, so I highlight particular paragraphs I think are helpful to our learning. So yeah.
Exactly.
Okay. The question before us is whether this rule of liability that we just talked about, as applied to an action brought by a public official, again, against his critics of official conduct, abridges the freedom of speech and press that's guaranteed by the First and 14th Amendments. So we're still talking about public officials, official conduct. I bring this to your attention because the language is going to become muddled in this action. Respondents rely heavily, as did the Alabama courts, on the statements of the court to the effect the Constitution does not protect libel. Never has. Those statements do not foreclose our inquiry. None of the cases sustained the use of libel laws to impose sanctions upon expression critical of official conduct of public officials. Again, official conduct, public officials. This is where we're starting. It will not be where we stop in this case. So it's like, I just want people to know, even within the case of New York Times versus Sullivan, we see drift. Whether it's sloppy writing or otherwise, there's still drift within the case. So it's like, I want to make sure you see this every time. Okay. But the court was careful to note that it retains and exercises authority to nullify action which encroaches on freedom of utterance under the guise of punishing libel for public men, as it were, public property. So public people belong to the public in like an ownership sense. Okay. And discussion cannot be denied, and the right as well as duty of criticism must not be stifled. Again, the idea, at least here, is we're talking about the government or officials therein. Okay. The general proposition that freedom of expression upon public questions. I sense a language change.
Oh, just a bit.
Oh, yeah, no. What just happened there? Oh, no. We're no longer talking about public officials. We're now talking about public questions. Oh, that's a different thing.
Yeah,
Uh-oh.
and the fact that the transition happened, because public official, you're kind of putting yourself, at least some of you are putting yourself in that vein.
Yeah.
But when you talk about a topic that might so happen to be a political hot topic,
Yeah.
does that then all of a sudden make you a public official?
There's a lot of difference in my mind between a public official and a public question. You
Yep.
know, a lot of difference between those two things. For example, our friend, with the Kenosha shooting, for example, not a public figure,
Mm.
but it's a public question. So, which is it, Supreme Court? Uh-oh. Danger, Will Robinson, danger. Right?
Just
The
a bit.
constitutional safeguards, we have said, were fashioned. Yes, you can, Stephanie. That's fine. The constitutional safeguards, we have said, were fashioned to assure unfettered interchange of ideas for bringing about political and social changes desired by the people. By the way, in chat, we do have general rules against insulting other members of the chat. That is a rule on my channel. You're allowed to disagree with people, but don't insult other people in the chat, especially my mods. You know, we don't make it personal here. We're discussing ideas. Thank you. All right. So again, we're talking about public questions now. We're talking about unfettered exchange of ideas, political and social change. It's like, wait a second. What are we talking about? Political discussion. Wait a second. What happened? You know, we moved without noticing we were moving. So, like, yeah, this is like, you notice these things. Okay, and then we see again, thus we consider the case against a background of a profound national commitment to the principle that debate on public issues. That's different language. Not public officials, not official duties, public issues. That's different language. Should be uninhibited, robust, and wide open, and may well include vehement, caustic, and sometimes unpleasant shark attacks on government and public officials. But wait a second, we're talking about public issues. So are those different things or the safer things?
But this quote stays and actually becomes a part of case law even further beyond that.
Yeah, I know.
It may well include vehement, caustic, and sometimes unpleasant, sharp attacks.
Yeah,
that is a bedrock principle under the First Amendment. Just because it's insulting doesn't mean that it's libelous or defamatory.
Yeah, absolutely. But you can see like just these language changes and why it leaves open ideas, right? Because we're blurring the lines between various things. So let's read a little bit further. And then we'll read a follow-on case which blurs those lines all the way. But this is the kind of thing that allows for that for legal argument in the future. All right, so now suddenly we're back to official conduct, right? A rule compelling the critic of official conduct to guarantee the truth of all factual assertions and to do so on pain of liable judgments, virtually unlimited amount, leads to a comparable self-censorship. Allowance of defense of truth with the burden of proving it on defendant does not mean that only false speech will be deterred, which is true, right? Because if we allowed liable actions more freely, then obviously it wouldn't be used just to censor the false. This is the whole idea of why we invented the idea of the slap and anti-slap, right? Because of this kind of stuff. That wouldn't come around for another 40 years, but still. Under such a rule, would-be critics of official conduct may be deterred from voicing their criticism, and even though it's believed to be true, and even though in fact true, because of doubt of whether it can be proved in court, this may have a problem. Okay. All right, so then the constitutional guarantees, we think, a federal rule that prohibits public officials from recovering damages for defamatory falsehoods relating to official conduct unless he proves the statement was made with actual malice, that is, with knowledge that was false or reckless disregard. This is why we're stuck with the phrase actual malice, people. This right here, because the Supreme Court just created a brand new legal term from nothing. Thanks, Supreme Court. That's great.
They like that, though. They like that. It's like they need to make new words up to express an opinion.
We could have called it something else.
Didn't have. I mean, maybe, but it became a part of jurisprudence from this point forward.
Okay. So then we say the privilege extends to a great variety of subjects, includes matters of public concern. Oh, wait a second. There's that public concern again. Public men and candidates for office. Oh, wait a second. That's a little bit different. Such privilege for criticism of official conduct is appropriately analogous to protection afforded a public official when he's sued for libel by a private citizen. The court held the utterance of a federal official to be absolutely privileged if it's made within the outer perimeters of his duties. So here, the Supreme Court is comparing the privilege that exists of the public official if they're defaming the private person, and says, well, we should give the same in reverse, which is generally true. Public officials enjoy quite a lot of latitude when it comes to defaming people.
Well, yeah, they have the bully pulpit. They have the bully pulpit.
Yeah. So as long as they're acting in their official capacities, you may well not be able to sue them for defamation. And so the Supreme Court's like, well, this is just kind of turnabout as fair play. If they have it for you, why shouldn't you have it for them? Which might make sense as far as it goes for public officials. But then again, there's all that that blending language about public concerns and public ideas. And what exactly are we talking about again? All right,
Kind of opens the door for some gray area.
Yeah. And then it said, we hold today the Constitution delimits a state power to award damages for libel actions brought by public officials against critics for official conduct. Since this is such an action, the rule requiring proof of actual malice, which we just defined 5 seconds ago, is applicable. And I believe that is the last quote I have in this case.
Well, let's hear your thoughts on this case, and then tell us what the next one does.
There's the original ad appended to the PDF as well that we saw earlier. So there's the original thing. So yeah, so as far as New York Times versus Sullivan goes unto itself, right, it kind of makes sense under its own terms. Public officials are public officials because they choose to be public officials. They run for office. Even in the case of like a sheriff, they run for office, and you have the right to criticize them, and you don't have to be factually perfect. So kind of makes sense as to a public official, right? Someone who runs for office, someone who holds a public office is a public official. Kind of makes sense. Well, but we saw some language in there that started talking about matters of public concern and started talking about public issues. So we saw some language in there that was blending the lines. And so then we fast forward from 1964 to 1967. Not that much further in time, right? So we get this second case, Curtis versus Butts, funny name, which extends this now to public persons, right? So this is taking that idea that New York Times versus Sullivan had and extending it out. So okay, it talks about a public figure who is not a public official may recover damages for defamatory falsehood, substantially endangering his reputation upon a showing of highly unreasonable conduct, constituting extreme departure from standards of investigation reporting ordinarily adhered to. That's New York Times versus Sullivan basically reworded.
That sounds like the actual malice standard, like with word salad added in.
Yeah. The New York Times standard applies to defamation actions by public figures as well as public officials. So we took that opening, and 3 years later, we drove it home. We drove the knife all the way home. In this case called Butts. We bring these two cases here to consider the impact of the decision on libel actions instituted by persons who are not public officials, but are public figures and involved in issues in which the public has justified an important interest. The public has justified interest.
Ooh,
that's a lot. That's a lot more.
This is the public stockholder, public shareholder argument.
Yeah,
like if the public participates and has a vested interest in the topic, does that then make every person that speaks on the topic a quote public figure?
Yep. So now we're taking that public figure argument, which public officials, and they have all those protections we talked about, and now we're ramping it right through to public people. And who are public people? Well, those who are involved in interests in which the public has interest. Well, geez, that sounds pretty open. So we've moved from a very closed concept to an extremely open concept within 3 years. And I think I highlighted some other stuff here, but maybe not, because those were kind of the key takeaways. Let's see if I highlight anything else. I might.
Well, so one comment that I got, and that was a call from a source on the line.
Ooh.
Certain statements, the statements have to have the requisite sting. They actually have to be a defamatory statement. They have to actually impute some type of sting where it would actually impugn the character of the person that the statement was made about. And with Times v. Sullivan, there was enough there in the aggregate that could tell you that those statements were talking about the sheriff to kind of impugn his character. But it's important, like, just to make a random statement that's false, that doesn't make it defamatory. It actually has to be a false statement that actually is defamatory. It has to hurt the person.
Right. Otherwise, you don't have any damages anyway. So, I mean, you can factor that. You can just factor that into the damages analysis if you want. Like, if it causes no harm, then it causes no harm. So, like, what are we talking about? So, yeah, I mean, you can consider that a separate element unto itself, as some states do, or you can consider it part of defamation. One of the things I say about is because, like, I don't know if I've ever read any two states that formulate defamation exactly the same way, but they're all exactly the same thing. So some of them list them as 3 elements, some 7, some 2, some 5. I'm like, it's the same thing. Just pick one. They're all the same. It's fine. So here we see how this is going, right? So it turns this consideration, this case. Okay, in this case, all right, Butts was charged with important responsibility of managing athletic affairs of a state university. So he has some affiliation with a public entity, but he himself is not a state employee. Okay, so he's affiliated with the university, but not a state employee. So we're saying, okay, this is a factor. And then the Supreme Court has this wonderful line. Even if this factor was to be given some weight, we're told public interest in education in general and the conduct of athletic affairs and educational institutions in particular justifies constitutional protection of discussions of persons involved in the equivalent to protection afforded of public officials. So yes, we have extended this concept out from state officials to anyone involved in education, and then basically we followed on to anyone involved in anything we care about, and bingo bango, that's how you get where we are as the case law continues to develop. But this is the formulations. It is significant the guarantee of freedom of speech and press falls between religious guarantees, I don't know if it means that much, but whatever, and the right to petition for redress. It partakes the nature of both. For as much a guarantee of individuals their personal right to make their thoughts public and put before the community. Oh, okay, wait a second. Now we're suddenly talking about their thoughts made public. Oh, geez, well, that's even broader still. I don't know. That seems we're opening this up. The dissemination of individual opinions of matter of public interest is an unalienable right. Well, that's true as far as it goes. The fact that dissemination of information and opinion, information and opinion, those are kind of different things. Information sounds like facts. Fact of dissemination, information, opinion on questions of public concern, again, is ordinarily legitimate, protected, indeed cherished activity. Does not mean that one may, in all respects, carry on that activity exempt from sanctions designed to safeguard the legitimate interests of others. But then it basically just goes on to nullify all that crap anyway, because it talks about this public figure stuff. And see if I highlighted anything else in here. Oh, okay. Okay, we note that the public interest in circulation of materials here involved and publishers' interest in circulating them is not less than that involved in New York Times. Oh, really? Oh, really, you say? Because, I mean, not to put too fine a point on it, but the stuff involved in New York Times dealt with, the Civil Rights March and Dr. King and, the sheriff with the police and the arresting and the boycotting. But this is apparently not less important. Okay. And both Butts and Walker command a substantial amount of independent public interest. Both, in our opinion, would be labeled public figures. And that is kind of where it all goes. Butts may have attained the status by position alone. And Walker, and this is where a lot of this comes from, right? And Walker, by his purposeful activity, amounting to a thrusting of his personality into the vortex of an important public controversy. Well, that language sounds really familiar, doesn't it? That's some quintessential tort law right there. Purposeful activity, purposeful availment, thrusting yourself into the vortex of the public. That's where it comes from. Right there. Both have commanded a public interest and sufficient access to means of counter-argument to be able to expose through discussion falsehood and fallacies. So yeah, this is just purposeful availment. So Butts by position alone, because he's in this, let's call it contractor role for lack of a better description, contractor role with the university. And Walker, because maybe not so much, but it's okay because he's thrust himself into the controversy. He's made himself in the public. And you see how this fairly narrow concept, this is why I'm walking through this in some measure. You see how this fairly narrow concept we started with in New York Times versus Sullivan, the public official, in his official duties with the police, nonetheless, who is maybe arresting or, barring doors and starving people. And suddenly 3 years later, we're talking about people who put themselves into the vortex of controversy.
Well,
we moved quite a lot there.
And this is a really big deal that I hope people actually understand. Like, look, a public official, the reason they were given that heightened standard was the logic is they knew what they were doing when they signed up to become a public official.
Mm-hmm.
Public officials had to voluntarily run. It
Mm-hmm.
wasn't, George Washington was the last person that basically was forced to become a public official. And even he had a little bit of his own doing in there. But public officials, they made that choice. They knew what they were getting into, and they did it. To say that something has become a public topic or a public issue,
Mm-hmm.
and that anyone speaking on that issue has now somehow voluntarily undergone the same level of consideration and understanding as the public officials did, it doesn't make sense. They don't match up, they don't mesh. But the Supreme Court just expanded it to kind of include everyone speaking on that topic in that category as those who ran to be in public office.
Mm-hmm. Yeah. And so you take this idea of becoming part of the government, and the First Amendment purpose, the fundamental First Amendment purpose is probably to hold the government to account. I mean, that's why in the First Amendment analysis, political speech is normally thought of as the apex of the First Amendment period of the purpose. Like, it's all well and good to be able to talk about things and have movies and TV shows and, entertainment, and that's all nice. But the fundamental purpose of the First Amendment is to challenge the government. Goes to Jefferson's idea. If we had to choose between a free government and a free press, I'd rather have the free press because of this kind of idea.
The free challenge.
So it's like, you want to be part of the government. Okay, great. But, we have the right to challenge our government. We kind of got that one in 1776, take a memo. And so we're going to, hold you to account because it's the way that we balance the ultimate measure of power, right? We, the people, right? It's the ultimate source of power. And we have the right to hold you to account and question you because you are ultimately the people's collective servants. And so you take that idea, and now suddenly you're talking about people who are just injecting themselves into public controversy, and they're one and the same of the same tier.
Mm-hmm.
And it's like, well, I don't know about all that.
Well, it's funny. We had our barrister friend on earlier today. We were talking on Alita's channel. We had the barrister friend that was on there and talking about the allocation of attorney's fees and how that system says that the loser has to pay attorney's fees, and how the U.S. American rule, we called it the American rule. It was that you had to pay your attorney's fees. It was presumed that you would pay them, and it made us more litigious. But it also did something else. It gave free access to the courts to the people, where they could actually go and combat their government. They could fight up against things that they thought were wrong. Same thing with the freedom of speech. We were so shocked by what the UK or the British government had done to that demonstration, to free speech, that we wanted to make free speech so open to allow everybody to participate. And then it was a game that we played with the Supreme Court of, well, how much do we actually control that? And that case law kind of developed a lot over time.
Yeah. Yeah, absolutely. Hold on one second. Okay. Anyways, carrying on. Where was I? All right. These similarities and differences between libel actions, I mean, these are kind of different things, but let's just treat them as the same. All right. These similarities and differences between libel actions involving people who are public officials and libel actions involving those circumstances, as in this case, viewed in light of the principles of liability, of general applicability of our society, leads us to the conclusion that libel actions of the present kind cannot be left entirely to state libel laws, unlimited by any overriding safeguard, But rigorous federal requirements of New York Times versus Sullivan are not the only appropriate accommodation. We consider and would hold that any public figure who is not a public official may also, on top of that, recover damages for any defamatory falsehood whose substance makes a substantial danger to reputation apparent on showing of highly unreasonable conduct constituting extreme departure. But basically, that's just New York Times versus Sullivan, and so the whole thing collapses. But yeah, I mean, these similarities and differences, well, we're just going to treat them the same. And like kind of ignore the rest. And that's the end of my prepared stuff, because that was enough to show you the constitutional stuff that we need to talk about.
I love it, buddy. I needed it. That's a very succinct description of how we got to where we got.
Yeah. And it's really amazing in some ways, because you dealt with this opening. You see this, I think you see this a lot in, well, I don't know about a lot, but you see this fairly often in law, where you have something that's like a good idea, and then you get this drift, like it's the creep of the principles. And I think, like, for example, another example of this would be, for my money, like Chevron versus NRDC, because you can see examples like that precede Chevron, or you can see the ideas preceding Chevron. But Chevron, at least for me, is where we went over the deep end, and it no longer started making sense to whatever principles we were trying to establish in the first place. And same kind of ideal too with Wickard. Like, the Wickard is not the first case that comes along. It's just it's the last step on the path of things where it's like you depart from, and it goes to show the dangers. I think it goes to show why a lot of lawyers get so concerned with precedent, and so concerned with doing something just this one time. Because we know, those of us who study history, we know that doing something just this one time has a tendency not to always stay there. It's not slippery slope fallacy. I'm not saying it has to occur, and it doesn't always occur. But we know from long-lived experience that it frequently occurs, enough so I always like to analogizing it to setting a brick down, and cementing it down. And we're like, well, don't put that brick there. We're like, well, what difference does it make? Well, when you build the wall on top of it, and you have to build in conformity, suddenly it makes a lot of difference where you put that one brick, all right? Because it now changes the entire geometry of the wall.
Well, and you look at the New York milk. Sorry, Kurt. The New York milk.
Go ahead.
But the New York milk cases under FDR, the expansion of the Interstate Commerce Clause, and I'm sure you have opinions on that. How that just bled into everything.
Yeah, I do. And I was disappointed with Scalia and his analysis in, was it Cohen versus California? No, that was not right. The pot case was Reich. Reich. Because it's like, it's too far gone. I think it was disappointing to see Scalia not try to push back in Reich, dealing with pot legality in California, because it's like, it's the same fundamental problem of like, I don't know how we read the Interstate Commerce Clause this broadly, and we've it is the foundation for a lot of federal law, but that doesn't necessarily mean it's good.
It doesn't mean it's right either. Like, just because there's this basis you can make a claim, do you have the right to make the claim everywhere?
Yeah, I don't know. So like, this is why I think this is also why the conservative originalist textualist conceit is the way it is. It's like, we'll just freeze everything in time, as it were, and let the legislature do it, because the problem is when the judges start doing things, even though it might be right in the moment, this is the hard cases make bad law territory. It's like, yeah, maybe I'm not saying necessarily. I don't honestly know if New York Times versus Sullivan should have gone the other way. I don't, because I'm a pretty strong First Amendment guy, and I want the ability to criticize the government. So I'm not sure that I'm opposed to New York Times versus Sullivan. I think I'm opposed to its extension. in this case, Butts, to be honest, because yeah, you should have the right to criticize the government. That's fair. And but this whole idea of just any public figure, and of course, then the real problem, which neither case deals with. I mean, this case, let's just point out the biggest problem of all. Curtis Publishing versus Butts is 1967. The problem with that is in 1967, the media landscape looks a little bit different than it does today. In 1967, there were newspapers and 3 stations on broadcast, and that's about it. The internet was ARPANET and was still a dream, in a researcher's eye in 1967. The first parts of what would be the internet were just being invented in 1967. So, the problem with this case is it just does not deal. It doesn't attempt to deal, because how could it deal with modern media realities? Because how you inject yourself in the public space and public sphere in 1967 is quite a bit harder on a practical level than today. So this just doesn't really. So I've often commented, like, people ask the question, like, am I a public figure, or are you a public figure, or is Legal Bites a public figure, or Emily D. Baker? And the honest answer is I'm not sure. And I'm not trying to be difficult or obtuse about it. It's just like I don't know what the benchmarks are in our modern reality. I mean, is it anyone with a YouTube channel? I mean, when you first started your channel, were you instantly a public figure? Were you a public figure even because you had subscribers on before you even had a post? Are you a public figure even before you comment? Are you a public? Does your first video, because your first video got 1 million hits, does that make you a public figure? What if your first video got 10 views? Because I mean, we're going to what you did, presumably, right? Your purposeful injection. So okay, what happens if that didn't happen, Rob? What happens if you put out that first video and you got 100 views?
And I love this point. I love this point because virality is something that we haven't really considered yet in this context of defamation law. Virality is a new topic that has not made its way to the Supreme Court. Right. Because you will have, and look, my video is, 1 million views. Great. Congratulations. There are people who put stuff out that get 10, 20, 30 million views on a viral tweet or comment. And you see it posted everywhere. Yeah. And did that person, when they were making that content, did they ever have any understanding that they would be subject to the scrutiny that they are put to? Yeah. Period. And did they now have to prove actual malice? Like, is that now the standard for them because they posted a video without knowing it would go anywhere or do anything? It's a really interesting topic.
Right. And this case is completely ill-equipped to deal with it. It's like, what was the line? How did you know, or did you know when you were crossing the line? Or did you, I mean, because like, at least when you ran for office, presumably you knew you were doing that, probably didn't come as a surprise. So what is this? And can it truly be, it's like, it can't possibly be true that everyone with a Twitter account, everyone with a TikTok account, everyone with an Instagram, everyone with a YouTube, everyone with a Twitch is a public figure. But if that's not true, what's the line? And this is where I throw up my hands and be like, I honestly don't know. I have no clue.
And I don't think the court knows. I don't think the court has that thrust upon them yet. They haven't really found the right case. And I don't know that they will. I mean, I thought they might have, with some of the Snapchat stuff, and it wasn't defamation. It was different. I was disappointed they punted that. That was free speech on the school grounds, the Snapchat girl.
Oh yeah, no, that's a great case.
But they punted it. They didn't actually get to the merits of it, which drove me nuts.
I thought they did a good job.
I mean, it did okay, but come on, like resolve
BL versus Mahoney, great case.
Yeah, but resolve one of the substantive issues of, is someone speaking off school grounds subject to on school ground restriction?
Yeah.
And the same thing goes to the public figure argument is someone who goes viral, are they a public figure? Have they entered a world where they have to prove that someone acted maliciously in order to recover for damage that they undoubtedly received based on something that went viral by no means of their own.
And of course, some people are trying to go viral. And many, if not most, if not nearly all of them don't. So here's a fun question. A person who is purposefully attempting to go viral, who doesn't, who posts, versus a person who doesn't intend to go viral, who posts, who does. Are they both public people? Is only one or the other? How do you know?
How do you even frame the question?
How do you even frame the
question? You can't start because you don't even have a premise. Like, how do you frame the question? What's the court supposed to decide?
Is it based on their intent? Is it based on the public's reaction? Does all my attempt to purposefully inject myself in the public space irrelevant if the public ignores me? How do you know? I don't know. No. Especially in today's age when those things can change and unchange in a fairly dynamic sense. And then, of course, it doesn't really deal with the possibility of when does someone stop becoming a public figure.
Yep.
It doesn't really deal with that either. So if I stop making content today, assuming I was a public figure in the first place, when do I stop becoming a public figure?
Or let's say that someone digs a video up that was made 5 years ago, and you have been out of the public scene for 5 years. And it's the last video you made, and they reassert that video, and they take that video and they publish it for a new topic, and you have not been in the public sphere for 5 years,
right?
But the topic is now fresh, and the topic is now relevant. What is that person?
Yeah,
I mean,
like the photo of that person who's like from 100 years ago that looks like Keanu Reeves, right? That gets circulated every once in a while. Like, you know, I mean, that person certainly didn't intend to be a public figure. Are they a public figure now because the public cares?
I don't know, but we could all hope to look like Keanu Reeves.
I mean, we could do worse. Well, you do look like Keanu Reeves.
Come on, dude. No. But it's a really interesting topic because this area of law, this defamation law, and to be honest, it wasn't something that I was that knowledgeable about.
Yeah.
And I really wasn't. My law partner had a really good take on it, and she's kind of delved herself into this. And the more that she talks to me about this stuff, the more I keep exploring these ideas. And honestly, you just hit a big one that I hadn't even thought of, is where do we draw the damn line? Where do we draw it?
I don't even know what you do for actors. Is it everyone who's an actor? Is it everyone with a SAG card? Does it matter? Is it every artist? Is it every one-hit wonder? Are one-hit wonders public figures? Are they still public figures 30 years later? I mean, this is the stuff that, like, I don't know the answers to these questions, and where things get really fascinating to me.
Yeah. And honestly, there's bound to be a case that's going to come up, and hopefully the case comes up sooner rather than later, because the problem is the longer that these things remain unresolved by the Supreme Court, the longer the question remains pending. Rather, the longer the question remains unframed. You frame a question, you at least have some decided body of case law around that framed question. But when you fail to frame the question properly, it leaves a ton of ambiguity in interpretation of whether there is a question, what the question is, and then what the resolution is to that question.
And one would presume it's only going to get worse through time, because social media is, geez, how old is social media? I mean, it's not even 10 years old. I mean, in any sort of modern sense, I realize, I mean, Facebook wasn't even really a thing. I mean, 2005 has been a thing for 15 years, maybe tops, 10 years since the iPhone came out, maybe. And maybe not the first generation iPhone, but that's when this is really when things popped off. So this has been a thing we've been dealing with basically since, we woke up this morning in, legal time. And, the law is just completely inequipped to deal with this.
I mean, it's crazy.
It's totally crazy. But I thank you for coming on and having a discussion. And I appreciate you coming on and talking about something I can geek the shit out about, because as you can see, I'm quite happy.
Anytime. And I love that last bit, the question part. That's invaluable. I mean, I love it.
Yeah. This is stuff I think about. This is stuff I like to think about is questions, because it's like, okay, what what does this mean? What is next? And it's just like that's one of the reasons I love these appellate argument stuff. I love Supreme Court stuff because it's like it just fills your head with questions.
Oh my
And
gosh, yes. And you hear the questions asked in the oral arguments, and you're going, you just raised like 10 more questions that are not yet decided, and you did it, and I'm really mad at you for doing it because you're trying to like yeah, no. I 100% agree. It's crazy.
This is why I geek out on this shit, bro.
It's so much freaking fun.
It's so much freaking fun.
It like the Boston flag raising.
Oh yeah.
I listened to that oral argument.
Did you listen to my commentary about the oral argument?
No, I didn't need to.
I lost my shit a little bit.
I think in my own head, I was doing the same thing you were doing. Like I was going, are you kidding me? Did you honestly just concede the argument in oral? Like, and it wasn't even a hard question. Like, did you honestly just take the position and affirmatively state it as your backbone position? That yes, we discriminated. Yes, it was because of this. Yes, if they changed
it's because they called it that. And Gorsuch asked the question twice. He asked it twice because I don't think he could believe the answer. It's like, but you would have done it because they called it that. But you would have raised the exact same flag. So the entire argument just goes to shit because this is I blew up on camera. It was on Law Nerds clips too, famously, with me just losing my shit completely over this because he took this really interesting argument and he just blew it apart. Because originally the idea was, oh, it's flying outside the Boston City Hall. There is the American flag, and there's the state flag, and there suddenly is the Christian flag. And a person coming by and seeing the Christian flag will say to themselves, it's the Christian flag outside our city government. Our city government appears to be supporting and sponsoring Christianity. This seems problematic to me. And it's like, okay. And then you go in oral argument and be like, oh, the problem is they called it the Christian flag. If they called it the Constitution flag, but it would have flown the exact same flag. So now our hypothetical person walking down the street is supposed to look at the American flag and look at the state flag and look at a flag that looks suspiciously like the Christian flag. But somehow they're supposed to know on the form that was submitted to the city council, it was called the Constitution flag. So therefore the flag that they see is an endorsement of religion. I'm like, no, doesn't make any sense.
No, I mean it was just plain old bad. I mean, and you know the other one was that Kavanaugh asked a question, and I'm not usually a fan for Kavanaugh's questions.
Yeah.
In the Mississippi case,
Uh-huh.
he asked a question that was basically saying, Plessy v. Ferguson, if that was decided yesterday, was it the wrong call? It was a remark. He is not one for those big questions, and he doesn't usually come in smart. That was a good. Oh god.
No, and I on some level I respected the advocate's answer, even though it's like it's a baller answer because he's like, okay, Plessy versus Ferguson is decided 67 or something like 1870 something like that.
Yeah,
he's like, okay, so he's like, so this is the whole exchange, and Kavanaugh's doing this whole exchange. He's like, okay, so it's decided. Can a case be reversed ever because it's just purely wrong the day it's decided? No, we need something more. So he's like, really, let's press this point. Okay, so Plessy versus Ferguson is decided. It's 1873 or whatever it is. Okay, 1874, Plessy versus Ferguson 2, Electric Boogaloo. Okay, the exact same case happens. With the exact same parties, because why not? I don't care. It doesn't really matter. Different parties, take your pick. The exact same case happens, right? The next year, and of course, the trial court, looks at Plessy and says, well, it must be this, right? And the Court of Appeal says, well, Plessy, it must be this. And for reasons that pass everyone's collective understanding, the United States Supreme Court grants cert. It's the exact same case. The very next year. Nothing has changed in the last year. So can we reverse because it was just merely wrong? And the guy actually says no. And I'm like, well, that's a lot of commitment to the principle. So I kind of appreciated his baller answer because how do you have the courage to be like, nope, need something more. Can't just reverse Plessy the next year. I'm totally okay with the Plessy in the next year. That sounds great. It's like,
I get it, but you have to appreciate the question was so perfectly teed up. And honestly, Kavanaugh doesn't do that very much. No. He's not very good at that. But that was the one time where I'm going to look at him and go, oh my word, man, you had him teed up. And the second he asked that question, I was like, oh, you fell for it. Like you walked right into that.
Yeah. Yeah, and but I do appreciate his commitment because he kind of is in a rock and a hard place, and I do appreciate that he stuck with it because he's like, well, if I say yes, which has got to be the right answer, but if I say yes, I mean, I'm conceding the point because I don't think anyone thinks that Roe was correctly decided. You might think it should stand for a whole bunch of pragmatic reasons. You might think it should stand for stare decisis reasons, but finding people that actually defend Roe on its own terms is kind of hard. So it's like, okay, if I say yes, I'm done. So I've got to say no, which means now I suddenly got to find Plessy versus Parenthood, Plessy versus Ferguson. This is my life now. And I'm like, well, I appreciate your commitment to defending your position with zealous advocacy. So it's like, I give you a +1 lawyering, even though you're in this very uncomfortable position.
I mean, it's crazy.
Yeah.
Why don't you hit some super chats?
Yeah. All right, I think there's only 8 of them, but let's put them on screen. Captivated Hearts. Thank you, Kurt. You're welcome. Ali says, Rob, did I hear you graduated from Nova Southeastern Law? So did I. Did you catch that Dr. Hughes went to NSU too?
She did.
A proud alumni. A Sparky 2, 1999. Shell CD. Good to see a fellow Tiger. You better believe it. Doing big things and making a difference. What are your 100K celebration plans? Go Tigers. Well, there's a case I want to cover, and I know I'm going to be covering that case because I've planned on covering that for a long time. Probably my favorite decision ever written. And beyond that, I don't know. Stephanie hopefully will help me think of some things. Good times. Shell CD became a new member. Influences by Arena Jacob. In my defamation case versus Taylor Lorenz, they're trying to say I was a public figure because I represent TikTok stars, and even one myself. Hope the losing my case proceeds. Yeah, I mean, we kind of pointed this out last time that you super chatted too, but like you were super chatting to bring attention to your case, and inject and kind of might be injecting yourself in the public space. So, just I hope it works out for you either way. Annie Boyd, I've always wanted to learn about the case. Bedtime, but saving it for later. Thank you both. You're welcome. And We Chic says, thank you for the legal lessons. Here are my course fees. 1999. Well, we'll have to work on the rest of the course fees, but And Michael D. Myers, will you list that case /breakdown? I'd love to see it. Also, I love you both. I mean, it's easy enough to Google. I mean, New York Times versus Sullivan, or
it's going to be on his channel. You can replay the video where he breaks.
You can replay the video and stuff and all that good stuff. So yeah, so that's how it all works. So what else should we talk about?
I don't know, bud. I mean, we've got more deliberation going on in this crazy case that is never going to end. I mean, oh yeah, you were Clemson, weren't you?
Oh yeah, Clemson. Go Tigers.
I was NC State Wolfpack.
Yeah.
We had you this year.
Okay, that's good.
Are you doing Daybell, by the way?
Yeah.
When are you going to pick that up? Now, like as soon as the deliberation is done?
Well, the case has been deferred to January. I might do the Halderson case if that's being broadcast.
Is Daybell? Are they going to get new counsel on that one? The Daybell case?
I don't know. I don't think so. I think they're going to have their conflict of counsel through and through.
No. Dude, I'm tuning in when you cover that one because that's too much fun.
It's a messed up case, and I don't even really understand it 100%. And so I have to get myself up to speed or not, which also would be entertaining. But I mean, just trying to unpack this and trying to listen to the case will be really interesting to try to figure out what the hell happened. Because it got this cult murder of family members, and they're wanted in other states for other murders. And it just is. And also my personal favorite detail, Lori over here was adjudicated mentally defective to stand trial for a while. So
yeah.
Imagine Sandy's coming up in this trial. So holy shit.
And how does the attorney not become a witness at some point? Like, it's just not possible.
Yeah. And then their counsel is completely incompetent for a while. That's fun. Yeah, the whole thing is messed up. So it'll be interesting to see what the evidence of the state looks like. And also, I still don't think they've announced whether or not it's a death penalty case yet or not. Because if it is, it would be the last death penalty case in Colorado. Or no, this is Idaho.
Idaho, yeah.
Yeah, I thought it was Colorado for some reason. Oh, well, never mind. Anyways, maybe they're also one in Colorado. Yeah. I don't post anything on locals because I don't know what to post there. I have a locals in case people want to support it, but, yeah. It is capital for both? Oh, okay. So they're charging with capital murders, which just adds an extra bit of interesting with her craziness, which has some basic... So trying to figure out whether or not they're guilty and trying to unpack all this is going to be interesting.
A freaking nightmare.
A freaking nightmare. So yeah, I'm going to cover that in January. If that's broadcast, I'm definitely going to cover that. And the Chandler Halderson, no, not Halderson.
That one's done.
The one with the parents being charged for the kid with the firearm.
Oh yeah. Have they announced a trial date on that one?
I was under the impression it was coming up relatively soon, but maybe I was wrong about that.
Yeah.
I'm not sure as a matter of law that the parents should be charged. And so that might be an interesting case to cover too. So that's definitely on my radar. And the Manson trial obviously is on my radar. So these are things. And the Murdaugh case, if that's being broadcast, is also on my radar because I know that's really big in my former home of South Carolina and has some big Southern interests. So these are all cases I'm looking at covering. So good times.
All interesting. Like the Daybell one, when you start covering that, let me know because I kind of want to see that from your side because I
see this nightmare.
Cool.
Yeah. Muffin and Mega Pints gives $5. If Amber Heard didn't bring the counter, what would the trial look like? Austin Halderson, yeah, I just came up with the wrong name. The case dealing with the parents being charged for giving their child a firearm or something was the one I was thinking about. But yeah, if she didn't bring the counterclaim, I think things would be a lot better. Her mental health doesn't come into issue. And she doesn't look completely wackadoo by making cases that don't make any sense.
Doesn't help her. I mean, every time it's a different story, a little crazier.
Yeah, really. Well, I'm going to sign off for now because I'm going to do some filming with Stephanie for some future releases. Law and Lumber, why don't you tell them where they can find you on all the mediums?
Law and Lumber on YouTube. You can find me at Law Lumber or Lumber Law on Twitter. Yeah, keep it up. We're going to start putting out new content. So
awesome.
Till then, see you then.
Make sure to check my guests and remember to do all the YouTube things. If the red subscribe button is red, it is red because it is angry with you. Please click the red subscribe button and be the change you want to see in the world by making it gray. Also remember to hit the like button. And did you know for a mere 99 cents, you can become an uncivilian? It's true. If you hit the join button or hit the link that the bot tells you about from time to time, you too become an uncivilian. What do you get for this benefit, you might ask? Great questions. Well, first of all, you get your name on screen when I'm using OBS. So not tonight, but you've seen it in the past where you have the names just scrolling on screen. You get your name on screen to show that you're a supporter. And also you get a cool little scales of justice by your name representing that you are one of the uncivilians and therefore are better than everyone else who doesn't have one. So you should definitely get one of those today. I've been Uncivil Law. Until later, my friends. I hope all is well. Cheers and goodbye.